I'm going to pass this over to Grace Schaub, who is our the legal intern at PMC. She is a rising 3L at Drexel Law, and I want to thank you, Grace, very much.
Thank you, Debbie. Hello, everyone. Thank you for joining today. We're so happy you're here. My name is Grace Schaub. I'm a rising third-year law student at Drexel, the Thomas R. Klein School of Law. And this session is the Lawyer's Guide to Legalese. So as a law student, I can relate to the difficulty of navigating legal jargon. I came into this without a lot of legal background, and often it's not easy to decipher these obscure terms. So let's get started. So jargon can sound like an entirely different language, and that's especially true for legal jargon. So not only is law already a notoriously complicated field that requires years of schooling to master, but legal jargon is often quite literally in a different language, and so the language used in law is changing. Many lawyers are now adopting a plain English style, but there are still legal phrases that baffle non-lawyers, of course. So this presentation is meant to help non-lawyers understand legal phrases and give lawyers ideas for explaining the legal phrases that they use. You can go to the next slide. And so we know that the language of law can be confusing. So in English, we often call legal language legalese. So we're going to show a short video that looks at some of the main kinds of legalese and why not all lawyers agree it's a good thing.
Is this the most complicated form of English? Legalese. It's the language used by lawyers. And if you've ever read the small print, you probably already know it can be confusing. Not only can sentences be very long, they also often include terms in Latin and old-fashioned words like these. Perhaps it's no wonder the Cambridge Dictionary defines legalese this way: language used by lawyers and in legal documents that is difficult for ordinary people to understand. Don't worry, it's even hard for native speakers. But why is it like this? Many lawyers say it's to make legal documents as precise as possible, so there is no ambiguity, while others admit it could be simplified. Whatever you think, we suggest you learn a few key phrases, like these from this series, because learning the language of law can help make you a better English speaker, and maybe even help you understand your rights. Just make sure you're sitting comfortably before you begin.
So an attorney named Clark Richards at a firm based in Texas has this great video online, which I've linked at the end of the presentation. And so I'll go through some of the points that he makes in the video. So like any technical discipline, there are specialty terms that apply in law. It's not dissimilar from math or physics or engineering. And so this is an issue because it's unlike those other disciplines, because legal language often affects non-specialists. This happens all the time because people are involved in lawsuits or they have to read contracts. And this language is embedded in these legal documents, and it's hard to understand. And so it's often frustrating for people to encounter this kind of language because it directly affects their lives. So this leads to some frustration with people who are interacting with the law maybe for the first time. There has been effort to modernize and use this plain language in the law to reduce the barrier between these intricate legal documents and the people who have to utilize them. But unfortunately, some of the language that we use in the law comes from ancient history, and it actually has no current legal bearing, but the language becomes habituated. So attorneys will use the same words over and over, sometimes not realizing that they're not necessary because maybe they're anxious that if they leave out one of the words, it might have some impact on the effectiveness of the document, but really it doesn't have a lot of meaning. So when you see at the top of a will, for example, it will say will and testament. Those words actually mean the same thing. So one is a French-derived word and one is an English-derived word. And so I'll get into why there are French-derived words in our legal language on the next slide. But there are a variety of these double terms that remain embedded in legal documents, and so most of which could be safely included. You can go back a couple slides, Kathleen. We're still on that same slide. So what we're left with is this complex technical language with a lot of specialty, or I should say technical discipline, with a lot of specialty language that sometimes cannot be made more simple. And so lawyers will assist their clients not just to understand the language, but also the complexities of the systems in which they find themselves once they have a legal problem. So if you go to the next slide, we can sort of get into the history of the language of English law. So the simplest version of language history would show that in the past 2,000 or so years, what we now call England went through three major linguistic eras. So first came Latin, which was brought to the country by Romans during the 1st century CE. Then a millennium later, the Normans took over the country and brought their French dialect with them. And then finally, English became the primary language around the 15th century. So for a long time, England was actually a trilingual country. So it had different languages being used in different contexts. So English was often used by regular people as the vernacular, but Latin and French were the more prestigious languages used in the government and the court systems. So if you were to attend a trial in, say, 16th century, you would have heard a combination of law Latin and law French. So it wasn't until about 1730 that English was made the official language of law throughout England. By the time English was the official language of law, Latin and French had already lodged themselves quite deep within the legal system. So law Latin and law French are distinct from their non-legal predecessors. So even when law French was in common practice in England, a Parisian French speaker would have had a hard time decoding it. So lawyers basically took these two languages and gave general words very specific meanings. So for example, the word tort in French, for example, just means wrong, but it very specifically refers to a kind of law that deals with civil cases in English. So because of how specific legal language became, it was impossible to disentangle English law from Latin and French, and you would have had to create a whole new vocabulary, which lawyers set in their way weren't too keen on. So when you look at legal jargon today, you can clearly see how French and Latin are still in constant use. So you can go to the next slide. So some companies have begun to implement plain language contracting that's more accessible and contains less legalese. So for example, plain language contracting is beginning to spread inside General Electric. So the example that you see here is a liability limitation clause, which is basically a provision in a contract that limits the amount of exposure a company faces in the event of a lawsuit is filed or another claim is made. So you have a jargon-filled original version on the left and the simplified version on the right. And so after reading this example, one of the GE lawyers commented, it's a little jarring because it's so user-friendly and plainly written. And she wasn't alone. So all who read it, lawyers and non-lawyers alike, were surprised at its plainness. So complex contracting has been the norm for hundreds of years, and in the legal field, old habits are pretty hard to break. So, but it's hard to argue that the idea that legal agreements should be easy to understand, but because contracts will undoubtedly contain some legalese, we just hope that this can be a helpful resource if and when you may need it moving forward. So you can go to the next slide. So one previous, I think, Kathleen. So understanding legal jargon is certainly important, particularly when it comes to journalists reporting on the courts and conveying information to the public. So I've just listed a few of the most used or the most obscure legal jargon. So let's go over some of those now. So first we have abuse of discretion. So this is a standard of review used by appellate courts to review decisions of the lower courts. And so the appellate court will typically find that the decision was an abuse of discretion if the discretionary decision was made in plain error. So it's a standard by which the appellate court determines whether a decision should be overturned. But it's important to note that this doesn't equate to, let's say, a violation of the judicial code of conduct. So if you found yourself reporting on this issue, it would be important to know the difference. So the abuse of discretion standard is used by appellate courts to review lower court decisions in both criminal and civil law when a lower court makes a discretionary ruling, which is basically a decision made by the trial judge where the law provides that the decision will not be reversed by a reviewing court absent an abuse of discretion. So on appeal, if a party challenges the ruling, then the appellate court will use the abuse of discretion standard to review the ruling. So next we have amicus curiae. So this means a friend of the court. And this is one that's not a party to a case who volunteers to offer information on a point of law or some other aspect of the case to assist the court in deciding a matter. So as a journalist, it might be important for you to report on this person or group who is not a party to an action, but has a strong interest in the matter. So this person or group will petition the court for permission to submit a brief in the action intending to maybe influence the court's decision. Next, we have burden of proof. So generally, this describes the standard that a party seeking to prove a fact in court must satisfy to have that fact legally established. So there are different standards for different circumstances. So if you're reporting on this issue, it would be helpful to know that there are different standards for burden of proof. So for example, in criminal cases, the burden of proving the defendant's guilt is on the prosecution, and they must establish that fact beyond a reasonable doubt. So that's the standard. While in civil cases, the plaintiff has the burden of proving their case by a preponderance of the evidence, which means that the plaintiff merely needs to show that the fact in dispute is more likely than not. So a preponderance of the evidence and beyond a reasonable doubt are different standards, and they require different amounts of proof. So the burden of proof is often said to consist of two distinct but related concepts. So there's the burden of production and the burden of persuasion. And so depending on the jurisdiction and the type of action, the legal standard to satisfy the burden of proof in US litigation can include a few different standards. So some of them are, again, beyond a reasonable doubt in criminal law, preponderance of the evidence in civil cases. There is the standard of clear and convincing evidence in fraud, in a will dispute. There's probable cause in the acquisition of a warrant or an arrest proceeding. There's reasonable belief as part of establishing probable cause. There's reasonable suspicion in cases involving, police stop and searches. There's a standard of some credible evidence in cases necessitating immediate intervention, like Child Protective Services disputes. There's some evidence in cases involving inmate discipline. And then there's, substantial evidence in many appellate cases. So there's a myriad of standards for different circumstances. So it's just useful to know that, there's not just one burden of proof. So next we have habeas corpus. So this is a writ that's often used to bring a prisoner before the court to determine the legality of their imprisonment. So a prisoner wanting to argue that there's not sufficient cause to be imprisoned would then file a writ of habeas corpus. And so it may also be used to bring a person in custody before the court to give testimony or to be prosecuted. So habeas corpus is mainly used as a post-conviction remedy for either state or federal prisoners who challenge the legality of the application of federal laws that were used in judicial proceedings that resulted in their detention. So other uses of habeas corpus could include immigration or deportation cases or matters concerning military detentions, court proceedings before military commissions, convictions in military court. So habeas corpus is used to determine preliminary matters in criminal cases such as an adequate basis for detention, removal to another federal district court, the denial of bail or parole, a claim of double jeopardy, the failure to provide for a speedy trial or hearing, or the legality of extradition to a foreign country. Next, we have a prima facie. So this is a case that is sufficient and has the minimum amount of evidence necessary to allow it to continue in the judicial process. So example, so various torts will typically have prima facie cases attached to them. So a plaintiff would typically need to prove that a defendant has met all of the components of a prima facie tort case in order to prove that the defendant committed that tort. So for example, the tort of trespass has a prima facie case with 3 components. So first, the defendant had the intent to invade the land. Second, the defendant invaded the land. And third, the plaintiff possessed the land and did not consent to the defense invasion. So if the plaintiff is not able to prove one of those components, then a court will likely find that the tort did not occur. So that's prima facie. And next, the last one on this slide is pro bono, publico or publico. This is a more well-known legal term, and it just means for the public good. And this is lawyers representing clients, without a fee. So those lawyers are to be working pro bono. As a side note, legal assistance can be expensive, and people don't often realize that there are pro bono legal service providers around the country that can help. So the Department of Justice lists providers for each state. So if you go to justice.gov, there are resources available. You can go to the next slide. So next we have Resjudicata. So this is a rule of civil law that once a matter has been litigated and a final judgment has been rendered by the trial court, the matter cannot be relitigated by the parties in that same court or any other trial court. So in your reporting, you might talk about how a matter cannot be relitigated in the same court, but the matter could potentially be appealed. It just can't be relitigated in that same court or that same level. Next, we have stare decisis. So this is the doctrine that courts will follow principles of law laid down in previous cases. And so stare decisis is similar to precedent. So reporters might often think of the US Supreme Court and how, although courts seldom overrule precedent, the US Supreme Court has explained that stare decisis is not an inexorable command. So when prior decisions are unworkable or they're badly reasoned, then the Supreme Court may not follow precedent. And so this is particularly true in constitutional cases. So for example, in deciding Brown versus Board of Education, the US Supreme Court explicitly renounced the case Plessy versus Ferguson. And so they refused to apply the doctrine of stare decisis. So the court decided that separate but equal, the standards of racial segregation were unconstitutional. Next, we have Voidir. So this is the process by which judges and lawyers select a petite jury from among those eligible to serve by questioning them to determine knowledge of the facts of the case and a willingness to decide the case only on the evidence presented in court. And so this is a French term, and it means to speak the truth. So as journalists reporting on the courts, it might be helpful to understand the difference between a petite jury and a grand jury. So a petite jury is going to be a group of citizens who hear the evidence presented by both sides at trial, and then they determine the facts in dispute. And so in federal criminal juries, there are 12 people, and in federal civil juries, there are 6 people. Grand juries, so that's a body of citizens who listen to evidence of criminal allegations presented by the government, and then they determine whether there is probable cause to believe that the offense was committed. So it's used in federal criminal cases, and so the government refers to lawyers as the U.S. Attorney's Office, who are prosecuting the case, and the grand jury proceedings are closed to the public, and the person suspected of having committed the crime is not entitled to be present or have an attorney present. States, interestingly, are not required to use grand juries, but the federal government must do so, and that's in the Constitution. And this last part, so we have a writ of certiorari, or just cert, it's a mouthful. So this is another more well-known legal term. So it's the order issued by the US Supreme Court directing the lower court to transmit records for a case for which it will hear. So the Supreme Court is usually not required to hear appeals of cases. And so this means that if there's a denial of cert, it will allow the previous ruling to stand. And then there's an allocator. So for PA-based journalists or those journalists reporting on PA matters, in PA courts, an allocator is similar to cert, but it's state level in Pennsylvania. So it's a petition to an appellate court for permission to be allowed to file an appeal. So an allocator petition is generally filed where the automatic right to appeal does not exist. So you can go to the next slide. So here I have linked a more extensive list of legal jargon as a resource for you all. It is available on our website at pmconline.org. As a law student, Black's Law Dictionary has also been a helpful resource while in school, and it is available for free online if in your reporting you should ever need to look up some legalese. But finally, I want to thank you for your attention this morning. I will now hand things back to Debbie, who will introduce our next speaker, who is retired Professor David Sonnensheim from the Temple University School of Law, and he will give a criminal law lesson.
So thank you very much, Grace. I also wanted, I've been looking at the chat, and I understand the impression that this legalese gives, right? But remember, our legal system came from, England, from France, and we have slowly but surely, I will say, the courts have been emphasizing the use of the more frequent use of plain language. Not all courts do it. We still have, 800-page opinions that contain words that are scary and and confusing, but there really has been a significant effort by the courts to use plain language. And again, thank you, Grace.